Well, here we are again, everybody. This is, as I say over here in my little chat, this is the Coronavirus Chronicles Part 2 for ADJ 206. Um, I've still got a voice, and we still got electricity in this country. We still got internet, so I'm still able to make these videos for you guys. I'm going to try to have these videos work out as about an hour each time I do it, and preferably if I can maintain this the technology and the pace, they'll be twice a week. You can look at them. You can look at them when you want. As soon as you see them, you can wait and do it on a Monday and a Wednesday, or you can do it in the middle of the night. It doesn't really matter. You can watch them and you can re-watch them. As you'll notice, the background's a little bit different now. They kicked us off campus with basically 3 hours notice. I was already home. I had to come back to campus, pick up a lot of stuff. And so now all the buildings are locked, so I'm going to have to do this stuff from home. So, but it's just me again, me in a room. So that's all you're going to get to see. And then, of course, I do have the PowerPoint. So let's get going. Um, Again, in this video, you will hear a password. And when you hear that password, write it down and send it to me in an email so you can get credit for having seen the video. And you'll see it in Moodle as video password. Video password, warrants, video password, warrantless, whatever. You'll see it. And by the time you get done with this video, there will be two passwords that you'll need to submit to me by email. I also, along with the first video, I posted again those two YouTube links of those entries, those search warrant executions that I considered uh, executions that were unreasonable. And remember that phrase, shock the conscience, right? Remember that. So I posted them as well. So you'll get to see that stuff. So it's not perfect. I'd much rather be with you guys, but it is what it is, and everybody's complaining. I hear nothing but complaints, but what are we going to do? So, all right, here we go. So remember where we left off, I think, was, again, this whole idea of elephant in a bread box, and that might sound familiar to you because I think that was the video password last time. And really that talks about the scope, and that is where can you search? When you're in a place with a search warrant, you're allowed to search in those areas in which the evidence might reasonably be found, and where a reasonable police officer would know where to look and where not to look. So if you're looking for an elephant, you can't look in the bread box, and we've been through that a million times. So that's the end of that. Okay. Continuing on with scope, a little bit of case law. I don't know if you guys are familiar with the word still. Still comes from the word distillery, and these are during the time of Prohibition, when the production of alcohol for sale was illegal in this country by constitutional amendment, people started, these bootleggers, they started to make their own whiskey, and they made it with these big things, like I think I told you the last time, were about as big as a washing machine, called stills. And I point this out because it does make a difference what you're looking for in your search warrant. And in Harris versus U.S., which was a 1947 case, the language that they use was this. Now, the meticulous investigation in looking for two small canceled checks, for example, would not be reasonable in seeking a stolen automobile or an illegal still. So if in my probable cause statement, and in my search warrant and my affidavit, and I have told the judge, and the judge has signed off. Remember that neutral and detached magistrate has signed off on my looking for two canceled checks that I think were stolen or whatever. I'm probably going to be able to, any place where I would look that's small, would be okay. But I might not be able to look in places that would be conspicuously housing something really big. On the other hand, if I'm looking for something really big, I might not be able to look for something like two canceled checks. So, if it says stills in my search warrant, then it's going to be easier for me to find perhaps some checks if they're lying down on the counter. But if I'm looking for stills, I'm not going to be able to search drawers of night tables and medicine cabinets to look for two canceled checks. So keep that in mind. That's the general rule about scope, and I'm not going to be able to deal with it too much more with you guys, so I want to make sure you understand that. Now, one of the things that we did talk a little bit is what can you do? What can police officers, we've talked about scope, where can you search, but what can police officers reasonably do to find what they're looking for. It's a little bit of a different analysis. And we talk about property damage. We said that it has to be reasonable and it can't shock the conscience. And pulling the whole wall off a house to get in to execute a search warrant probably shocks the conscience and could allow a police agency to be sued by a landlord, for example, or a homeowner that people live in the home that he owns that was destroyed by a pull or one of these other methods they have for taking a wall off a house to get in. But the next question is, and this is one that will appear on your final exam, and I think on your next quiz as well. I make a big deal about this. Is can a police officer detain you if you happen to be present when they execute a search warrant at a house that you happen to be sitting in? And there's a case on that, and I'm not sure if we talked about it or not. We think we may have. The case is Michigan versus Summers, a 1981 case. And Michigan versus Summers is based. You drive down the street, and every time I ask this question, there's usually some students that have been through this. You drive down the street and you see this thing. You see 4, 5, 6 people sitting on the curb in flex cuffs, hands behind their back. My guess is that they are people that were inside a house that a search warrant was being executed on, right? And Michigan versus Summers answers that question for us, and that is, can we detain and put handcuffs on people that are in the house that is subject to an execution of a search warrant? And the answer, of course, is yes. Can anyone imagine why? Now, this is one of those things I'd be asking you in class. Why do you think that when I'm executing a search warrant, me and my buddies, we're executing a search warrant, why do you think it's okay for us to take everybody in the house, put them outside on the curb, put cuffs on them, and have them sit there, at least for some period of time? Not forever, right? We'll talk about that. For some period of time. Why do you think that would be the case? Well, I can't give you too much time because, I would sit here forever and you wouldn't answer. So I'm talking to a blank screen. But anyway, why? Why is that? For the same reasons that, generally speaking, we allow a lot of these things that we do as exceptions to search warrant, search incident to arrest, which we'll talk about later today as well. And that is public safety, officer safety, and most importantly, when we're talking about the context of a search warrant, this idea of the orderly completion of a search. In other words, if I'm going to search a house, I can't have people running around in the house. If I'm going to search a car, I can't have you seated inside the car. I have to get you out of the car. And I can get you out of the house when I'm searching the house. Now, it's possible that I may be making arrests as a result of what I find inside the house, so I'm allowed to keep you along the curb during the execution of a search warrant, not because I have individual probable cause for you or you or you or you, but because I need to be able to keep you in one place in order to be able to protect myself, to be able to conduct an orderly completion of the search, to do it in an orderly manner without stepping over people, and to prevent you from running away in case I develop PC, probable cause, to find that that there's something in the house that would allow me to arrest you. Okay? Now here's the kind of thing, I think I actually put this on your next quiz or on your file, this particular fact pattern. Cops prepare to execute a search warrant, right? Surveilling the property, they're hanging around outside, they've got the warrant, and they see 2 men walk out, get in a car, and drive away. Now remember, they haven't executed the search warrant yet. They're just surveilling the place with the search warrant in their hands. They just want to make sure, they want to know who's inside, who's left, who's going in, etc. Right? Now, before they execute the search warrant, police follow these 2 guys walking down the street, stop them, pat them down, and find incriminating evidence. Of course, if there hadn't been incriminating evidence, there wouldn't have been a conviction, and there wouldn't have been an appeal, and we wouldn't be reading the case right now. Right? So this is the question. Does Michigan versus Summers apply? In other words, can I use Michigan versus Summers to do what? To stop these guys, put them in cuffs, put them on a curb. I haven't executed the search warrant yet, right? This is just all in advance of the search warrant, in the interest of officer safety, orderly completion of a search, and prevention of flight. Can I do that? What do you think? I'll give you 5 seconds. Do you think Michigan versus Summers allows me to stop these guys that are there? By the time I get them, they're a block away from the house. What do you think? I hope that you're thinking that maybe the answer is, I don't know about that. I'm not sure that Summers really applies there. Now, can we create a bright line rule? This is one of those things we talk about, bright line versus case by case. And I think the answer is, yeah, you probably could create a bright line rule. And that is this. Michigan versus Summers does not apply. I cannot stop people prior to the execution of a search warrant if they are so far away from the premises in question that it doesn't endanger officer safety, or proper orderly completion of a search, or prevention of flight. Right now, if those three things aren't at issue, then the chances are I can't use Michigan versus Summers to drive 2 blocks down the street and stop 2 people who just left the house that I haven't executed a search warrant on, but that I'm going to. Right? So keep in mind that it has to be kind of immediate, it has to be in the immediate vicinity of the premises, and it has to be with these three things in mind. Right? So those are again, it's applying law to facts. You guys just went through that in your midterm. You know the drill, right? Okay. So general question: this is you guys. You're out there and you're in uniform. You're the first through the door. You got 4 or 5 guys behind you, and you're executing a search warrant. What can you do to people while you're executing a search warrant? Right? And this is a great example, right? And I'm going to make it as simple as I can. And these should be the tools that in your toolbox or the Fourth Amendment tools that you should always go back to. First of all, can I search them? Can I search people while I'm serving a search warrant? Well, you guys know the answer to that question. And the answer is what? I can search them if what? If I have probable cause. If I don't have, that's what the Constitution says. That's what the Fourth Amendment says. If I have probable cause, then I can search people inside a house, right? Remember, the search warrant isn't probable cause to arrest. It's probable cause to believe what? I'm trying to make use of my hands. My hands are down here. I have to have them up here. When probable cause is what? Probable cause is information which in its totality would lead a reasonable police officer to believe that a specific place contains specific evidence of crime. It's not a carte blanche, a blank check to go arrest people inside the house. So can you search people when you're executing a search warrant? Well, go back to the basics. Do I have PC? If I ain't got PC on a specific individual, I can't search them, right? Now, can I frisk them? Now, that's a little bit of a different story. I can frisk somebody if I have a lower standard. You guys know what the lower standard is because we just covered it. That reasonable suspicion that I have to be able to articulate in a court of law, right? Which is that there is ongoing or imminent criminal activity or criminal activity which is afoot. I'm pointing to my foot right now. Remember that? Yeah. And that is if I believe that there is a risk to an officer or for officer safety, or if there's criminal activity afoot, yeah, I can probably pat you down, right? Now, what would I be patting you down for? You guys know what I can pat you down for, right? I can pat you down for, you know this. What's the scope of a Terry frisk? The scope of a Terry frisk is that I can search for anything that I reasonably believe to be, and I hope you're all saying under your breath, or maybe out loud, a weapon. That's right. Is it possible that when I'm executing a search warrant, that I would need to pat somebody down to make sure that before I sit them out on the curb, they don't have a knife or a gun on them? Oh yeah, heck yes, right? So rule of thumb is this: if you happen to be in a house that's getting searched, wrong place, wrong time, hey, when that happens, if you ain't a threat, if you don't live there, if your stuff's not there, the chances are at some point you'll be allowed to leave, right? But you might have to go through this thing under Michigan versus Summers before they let you out, right? Before they let you go. Now, these people here, what do you think? Are they detained? Are they stopped? Are they arrested? What can you conclude? Well, we know what the test is, what Royer is, and, we look at the duration of the stop and the degree of intrusion and, how many cops are out there and, would they reasonably believe that they're not free to leave? And, it certainly looks like, since their hands are apparently cuffed, it certainly looks like these people are under arrest, right? Keep in mind, though, that because it may have happened during the course of the execution of a search warrant, that maybe under Michigan versus Summers, they're just detained, right? They're not really under arrest. So you can see that just because it looks like an arrest under certain case law doesn't mean it is an arrest. It depends on the circumstances, right? If this were not the execution of a search warrant, right? If this were just garden variety out on the street, I'd say, dude, these people are under arrest. There's no question about it, right? I mean, look how, that's a significant intrusion according to Royer, and that would probably have evolved into an arrest, right? So just doing the analysis. Okay, so we're gonna end this part of our study of criminal procedure today by sort of summarizing what goes on with your garden variety search warrants. We're going to pick up a little bit of some other stuff, different types of search warrants or warrants, but remember that it has to be, in case you're wondering, it has to be executed promptly. In the state of Maryland, if I'm not mistaken, by statute, search warrants must be executed within 15 days. That's because, why? Because probable cause inside of a search warrant goes stale. That's the word we use. In other words, what I think is here today, 15 days from now, might not be there anymore in the house, and so the search warrant is invalid. But arrest warrants are a little bit different because probable cause, unlike love, lasts forever, right? If I have probable cause to believe you committed a crime and I haven't found another suspect to believe, that I think did it, then the reality is that the search warrant is going to last forever because it's based upon PC to arrest, PC that a specific person committed a specific crime. But it has to be executed, if it's a search warrant, it has to be executed relatively promptly. You can't sit on these things by statute for more than 15 days. You might, that picture kind of got in the way there, sorry. You might see that a lot of search warrants appear to be executed at night. The reality is the execution of search warrants during the night is strongly disfavored. We don't like the stress that it causes to residents inside homes when at 3 o'clock in the morning they hear people breaking their door down. So if you can do it during the day, do it during the day, right? Of course, if it's an arrest warrant, it's a different story because I want to execute it when I think the guy's in there, and if he's in there at 3 a.m., that's when I'm going over. Now, what about a protective sweep? And we'll talk about that a little bit. I think we talk about that coming up. Can I do, which is essentially the equivalent of a Terry frisk of a house? Can I go through the house first before I start searching in medicine cabinets and in looking under tables and under couch cushions? Can I do a protective sweep of the house, which is essentially a Terry frisk of a house? Now, of course, you're not going to go to the house and pat down the house. Okay, you do the windows, I'll do the porch. But can I go inside the house and do the equivalent of a Terry frisk of a house? And the answer is yes. And we call that a protective sweep. And a protective sweep is basically looking for, what I'm looking for, right? I'm looking for people and I'm looking for weapons. Why am I looking for people? Because people are likely the ones that have the weapons, right? So keep that in mind, that I can do a protective sweep before I go in, before I actually do the searching. I'll send people through, clear, 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 and then I'll begin my search. I want to make sure there's not anybody hanging around behind a door, with an AR-15 rifle, Okay, and then scope and manner, how do you do it and what you can look for? Those are the questions that are asked by scope and manner. Again, what you can look for has to be based on what you're looking for. Where you can look has to be based on what you're looking for. I mean, that's it. Where the item might reasonably be found, and where a reasonable officer would know where to look and where not to look. You have to avoid this excessive, unreasonable damage that, what's the phrase? Shocks the conscience. Where are my hands? Earlier. Shocks the conscience, right? And you can't search guests or third parties in the house. We just talked about, if there's people just hanging around, you can't just willy-nilly search everybody who's in the house unless you have probable cause to believe that those individuals have committed a crime or that they're in possession of some dangerous weapon, right? Or something that could be dangerous to public safety. So if you're in a house that's being searched, come and talk to me. If you got searched when you were in a house, I hope you're not. But remember that the law says that we can just go back to basics, that if you're inside a house that's being searched, the officers need PC to actually search you. Or they don't need PC if all they want to do is frisk you, because they want to make sure that in order to complete an orderly search and to protect officer safety, they're going to pat you down to make sure you're not carrying a weapon, because while they're escorting you out of the house to sit on the curb, they don't want you pulling a gun on them, right? So that's, again, it's all about these levels of intrusion. Higher levels of intrusion require higher levels of justification under the Fourth Amendment, right? I hope this is all starting to make sense to you guys, right? All right. I thought I'd throw this in because we hear a lot about these things lately, and these FISA warrants, which I'll get to as well. There are these things called Title III warrants, U.S. Code Title III. These are this is under the Electronic Communications Privacy Act. And I'll tell you what, these laws preempt state laws and wiretap laws. So, if you got a Title III warrant out against you, or against, what your communications, it's a pretty big deal. It's basically a federal wiretap is what it is. Now, what do I need to get one of these Title III warrants? First of all, remember that Under the Fourth Amendment, our communications, right? You remember Katz? Remember the Katz case? I hope you do, right? Katz tells us that our communications are part of what? They're part of our person. Under the privacy doctrine, when we made that transition from trespass doctrine to privacy doctrine, Katz said, well, okay, what are communications? Are they houses, papers, persons, and effects? Because that's all we have under the Fourth Amendment. And of course, Katz tells us that our communications are protected as part of our person, right? So, the question is, what about electronic communications? What about things like, emails, right? Or oral communications, right? Specifically, when we talk about Title III, we're more concerned about taps of your electronic communications. And those are the things that you send either through, it could be your phone, which we'll talk about, which is another layer of law, or your emails. So to what extent are your emails protected? Or other forms of electronic communication. This is the bottom line, guys. Electronic communications, and that is, and for the sake of making it easy, it's emails. Emails between private individuals and the general public are not protected. Now, what does that mean? Can you imagine a place where you have sent it could be an email, or it could some other kind of electronic communication, and you guys know that you do this all the time. You're always communicating electronically, either by email or what? Instagram, Snap, Facebook Messenger, you name it, right? There's all these platforms for you to communicate electronically with somebody else, right? Keep in mind that when you do these, every time you send out a communication between yourself, between you, and which is accessible to the general public, that means all your friends, all the people on your list, whatever. Generally speaking, guys, I'm telling you what, that ain't protected. So be careful what you post online. Be careful what you post online, right? The government can get at it, right? Remember, again, the Hoffa case, which was on your midterm. And the Hoffa case talks about what? These knowing disclosures, right? These that suddenly waive your reasonable expectation of privacy. These consensual communications that you just engage in willy-nilly between yourself and other people out there in the universe, right? Pictures of yourselves, all of those different apps you can get where you're saying stuff and posting pictures of yourselves, and TikTok and all that stuff. Is that what it is? Yeah, my daughter loves that. And this is like the most popular app in the world. Did you know that? Anyway, they're not protected. So if I want to get one of these warrants, right? There's a couple things. It's fairly difficult to get your standard Title III warrant of an electronic communication, right? Why? Because we want to make sure that that officers have done pretty much everything that they need to do before getting the warrant, and that the warrant should be a last resort. And the list here I have is, these are the things that you pretty much have to establish before you end up with a Title III warrant, right? And that is, why do I need the thing? Why? This is what the officer has to establish. Why do I need a Title III warrant, right? Where am I going to be intercepting these communications from? House, business, cell? What other types of investigations have I done before I've gotten to this point, right? And have these investigations failed, right? If I've failed in a couple prior investigations, that okay, now we'll let you try this Title III warrant, right? You have to be very specific about how long you need it to be in place. 1 week, 2 weeks, 3 days. They're going to start you off small. They're not going to let you do it for 6 months, right? You have to have probable cause in your Title III warrant under this federal act that establishes that you're actually going to get something relevant, that you're going to be able to intercept relevant communications, and it's not going to be, recipes for chocolate chip cookies, right? That there's going to be something juicy there that you can use as part of your investigation, right? And you have to let the court know what the results were of previous warrants that the court issued. What happened there? What did you get from that information? So again, these are, again, they are protected. These communications are protected. Some are, some aren't. The ones that are protected will expose you to a Title III warrant. They ain't easy to get, right? Under Katz, we know that this is part of our person, but they can be gotten. Bottom line, for the stuff that ain't protected, careful what you post online. All right, let's move on. No warrant is required for that stuff. Okay. I wanted to talk to you a little bit about, if you follow politics, and this is a while ago, but it still comes up. Has anyone heard about these so-called FISA warrants? The FISA is the Foreign Intelligence Surveillance Act. It's a big deal has been made about it. in the 2016 election when Trump was running for president, because he had a guy working for him in his campaign whose name was Carter Page. Now, Carter Page was subject to a wiretap that was issued secretly on the basis of FISA, the Foreign Intelligence Surveillance Act. Now, the interesting thing about this is that these courts, these FISA courts, well, what a great job. I'll tell you what job would I like after I'm done at HCC? I want to be a FISA judge. Nobody knows who you are, where you are. Nobody knows where the courtroom is. It's this secret network of judges and courtrooms that allow federal agents to come in with information that indicates that individual people have specific information that would be categorized as foreign intelligence, what the Russians are doing, what the Chinese are doing, right? And the target of these investigations under FISA have to be foreign agents or foreign governments. They really shouldn't be Carter Page, right? So what happened? There has to be some suggestion that whatever communications I'm intercepting through these FISA warrants, these FISA wiretaps basically, are going to be used by some foreign power or some foreign agent to somehow damage the United States. It's really secret stuff. You know, I mean, if I were in class with you, I'd probably use a different word. It's real under the table, nasty government, down and dirty stuff, right? They got their own secretive courts and they issue warrants, right? So I don't know if you remember this from the Hillary Clinton days, but what happened was this guy, Christopher Steele, who's like a James Bond type, he created this dossier, which has now come to be called the Steele dossier. And in it was a bunch of nonsense information that had been made up about how the Trump campaign was involved with the Russians. If you remember, Robert Mueller did a whole 2-year investigation on that. Turned out none of it was true. And that's how they justified it under FISA. And what they did is this poor guy, Carter Page, some federal prosecutor goes to the FISA court with the Steele dossier, which has a whole bunch of nonsense, made up, fake news information saying that Trump was colluding with the Russians to help him win the election, which of course was nonsense. Anyway, don't get me started. So as a result, the judge, unbeknownst to anybody, because it's completely secretive, issues a warrant, a FISA warrant, against Carter Page and listens to his phone calls to see what he's talking about. If he's talking to the Russians, and if he is he talking about vodka or is he talking about, foreign information and intelligence? Anyway, I thought I would raise that to you because you may hear about this FISA court and FISA warrants and Carter Page and Christopher Steele. I just wanted you to have an idea from current event standpoint, where all that came from, right? Now, one of my favorite subjects, this is relatively new law, guys, is your cell phone. What level of privacy, what expectation of privacy do you have in your cell phone? There's some new law on this. Carpenter versus U.S., which is a 2018 case, tells us what you do have privacy in and what you don't have privacy in. Keep in mind, just like a car, remember we talked about the automobile exception, you have a reduced expectation of privacy when it relates to any information that you knowingly share with a third party, including, hint, hint, Verizon, Sprint, AT&T. I mean, think about it. On your phone, you got all this stuff. You got names, you got addresses, you got contact list, you got pictures. Your Snap is on it, your Instagram. Everything's on your phone. Let me tell you, my friends, you have shared all that with Sprint. I use Sprint. Everything I have on my phone is shared willingly with Sprint, and as a result, I have a reduced expectation of privacy. Again, it's careful what you post, careful what you put on your phone, because what you put on your phone, guys, it ain't yours. It belongs to Sprint or, T-Mobile or, AT&T or whatever company you have. And believe it or not, when you signed up for your phone, you signed those rights away. You acknowledged that was the case in that contract that was like 25 pages that you just went to the end and signed. This is the kind of stuff that you're acknowledging, right? So that information that's on your phone, all the police have to do is call up Sprint, say, hey man, can you check the photos that are stored on the phone of Andrew Kramer? I want to see if he's got any pictures of any obscenity or pictures that indicating that he's engaged in the trafficking of children or whatever, right? That gets done with a phone call. You don't need a warrant for it because you have a reduced expectation of privacy in it. But, and this is where it gets kind of interesting, the so-called CSLI, the site location, cell site information location, or location information, cell site location information. A lot of letters in there. Cell site location information is where you are. Now I'm going to say that again. For cell site location information, they need a warrant. This idea that they can track your phone, you've seen this. Have you ever watched any of these crime-solving shows where they could tell where your phone was pinging, or where you were at any given time? That they need a warrant for. Now that's under Carpenter versus U.S. So if they want to, I mean, I think I'd rather have this require the warrant and this not. But the warrant is not required for the stuff on your phone, for the content on your phone, but it is required for the location, for where you are, that is derived from your phone. If I want to find out where you are by checking out your cell phone, I got to get a warrant. And the language from Carpenter was this: that we don't give up our Fourth Amendment rights just by switching on our cell phones, which is what happens. When you switch on your cell phone, you're basically telling the whole world where you are, right? You're pinging off of towers. We don't give up our Fourth Amendment rights simply by virtue of turning on our phones, right? So if police want to use that to find out where we are, dude, get a warrant, right? They have to get a warrant. And I hope that clarifies things a little bit. And this is your classic, your tower, and shows pings, and it shows here's your towers, and here's here's the cell phone company, and here's where you are, and this kind of information that they can get to solve crimes. They need a warrant for that, right? So don't be afraid that some cop is going to know where you are, right? On the other hand, do be afraid that they're going to find out what you have on your phone, because all that requires is a phone call, right? Okay. All right, guys, so this is what we're going to do. We're going to start, and I think I entitled this video today, when you see the link is going to be the end of Warrantless, end of Warrant, and start of Warrantless. So we're going to talk a little bit about what I can do, what I can get as a police officer, as a state agent, without a warrant. Now, for some of you guys, this is going to be, if you've had me in ADJ 101 or even in 102 to some extent, some of this is going to be review. But we're going to drill down at a lot more case law detail than we normally do. And I want to start off with just kind of a summary, right? The idea that what you get as a police officer without a warrant is going to be, your lifeblood. I would say that as a prosecutor, as a drug prosecutor, I would say probably 70% of what we got was with search warrants. But as a sort of garden variety prosecutor, and just general patrol work that you guys will be dealing with in uniform, you will not be dealing with warrants. You may never see a search warrant as long as you're on patrol, right? Most of what you're going to be doing is without a warrant. And so these are the things we'll go over. The SIA, the search incident to arrest, the exigent circumstances, and among those are hot pursuit, escape. I don't think we'll talk about escape, but we will talk about hot pursuit. Highly evanescent evidence. Evanescent means something which goes away quickly. So, steam, for example, goes away quickly. Snowflakes are highly evanescent. You hold one in your hand, and as soon as it's in your hand, boom, it's gone. So if you have evidence that's going to go away quickly, that's an exigent circumstance. The automobile search, the automobile exception, and of course my favorite, which is probably what will yield you as a patrol officer the most evidence, in your career, is the plain view seizure. We don't really call it a search because I'm seizing from plain view. I'm not really searching, right? Okay, so let's start with what I consider to be the hub of the wheel, and that is the search incident to arrest. Now, Chamel versus California was the more modern case that led to this concept. That was a 1969 case. And, here's poor Mr. Chamel, at home, and he's arrested, and for burglary of all things. I like the old cases because the crimes were a little bit different. He was burglarized a coin shop. All right. They have a warrant for the guy. They wait for him to get home. And when he does, he's arrested. And police, guess what they do? They search the whole house. Now, you guys tell me, if I arrest you in your house with a warrant, can I search the whole damn house? Well, this is the question that came up. And of course, Mr. Chamel won this case because they found evidence throughout the house, and the Supreme Court said, wait a minute, you can't do that. Chamel and its progeny is a word we use to describe everything that came after Chamel that deals with Chamel, right? It's children, basically, is what it means. Chamel and all its similar cases tell us what the police can do after arresting somebody. Now, what can they do? Well, I can tell you one thing the Chamel court said they can't do, and that is they can't search the whole damn house. They can search, and you know where they can search. We'll talk about that in just a minute. What they can do for a couple distinct reasons, all considered under that concept of public safety. Public safety. They can do whatever they're allowed to do, which we'll talk about, to prevent harm to officers, harm to the community, and to prevent destruction of evidence. So you know that I can, in a search incident to arrest, I can do this. Right? Clearly, I can stick my hands in your pockets to make sure you're not destroying evidence or that you're not grabbing a weapon, right, to prevent harm to officers, right? And that's what Chamel, we think is a great victory for the state. It turns out it is, but it turns out that it was a victory for the bad guy. It tells us as police officers and as prosecutors that we can do something to you after we arrest you. On the other hand, it told police who arrested Chamel that, hey, one thing you can't do is you can't search the whole house. Right? You can search and we know what they can search. We'll talk about that in a minute. It has to do with a bird, right? All right. Before we get into that, what kind of arrests justify my ability to search you incident to arrest? For example, can I only search you incident to arrest if I've arrested you for a violent crime? Burglary, first degree assault, attempted murder, kidnap, rape. Or can I search you incident to arrest after any kind of arrest? And the answer is, you're probably not going to like it, but I can search you in any kind of arrest. As Rehnquist said, and Rehnquist, this is Judge William Rehnquist, my hero. The guy, wasn't a great public speaker. He was kind of tough, he stuttered, and he wasn't particularly articulate. But I'm telling you what, head-wise, this guy was a genius. Anyway, I love Rehnquist, but don't get me started. All right. He said that all arrests can generate a search incident to arrest. Why? Because custody, basically in English, what he's saying was custody in general. I don't care whether it's custody for driving while suspended or custody for first-degree murder. Being placed in custody is dangerous to police officers. When you put somebody in custody, it's dangerous to the police officer. And as a result, and much more dangerous than a Terry stop, right? So I don't care whether I've arrested you for spitting on a sidewalk. If you're placed under arrest for anything, I, as a police officer, can search you incident to arrest. That's the law, right? So that's why, we used to generate a lot of righteous searches from people who were stopped for 3-point driving suspended violations. People who didn't pay a fine, right? So they get arrested for not paying a fine. People who didn't show up in court, bench warrant. Hey man, I don't care what you're arrested for. If you're placed in custodial arrest, I'm searching you. That's the law, right? So, of course, the arrest has to be custodial, which most arrests are. I can't imagine, that it isn't. And even if it takes place for a traffic offense, DUI, whatever, anything that results in a custodial arrest, my friends, you're getting searched. Okay, now, are there some restrictions on it? Yes. First of all, and I think we've talked about this. By the way, this is Vladimir Putin, who is the president of Russia, and he's holding a fish. And the point I'm trying to make there is that the probable cause has to exist before the arrest, right? You can't go on a fishing expedition, right? Which is the legal term that we use for cops that are just sort of looking for something, and then they find it, and then they go, wow, look at that. Hey, I got probable cause. Now you're under arrest. The PC has to exist before the arrest. There are no fishing expeditions, right, like this one. That looks like a hell of a nice trout that he's probably got there, but who the hell knows? He's a real tough guy, by the way. Rides horses with his clothes off, and with his shirt off, but with his clothes on. No fishing expeditions on less than PC. PC has to come first. So, then once you have the PC, then you're talking about search incident to arrest, all right? Now, interestingly, can the search be before the actual arrest? In other words, if I have probable cause, let's forget about the no PC. Let's say I have PC. Can I actually search you before I make the formal arrest? Before I spin you around and put cuffs on you and say the magic words, you're under arrest? The answer is yeah. This, and the answer there is probable cause. As long as there's probable cause, even if I haven't actually placed you under custodial arrest yet, I can search you. PC, for your purposes as police officers, as patrol officers, whether you're Department of Natural Resources or Smithsburg or Boonesboro or Maryland State Police, probable cause is a shortcut. It's another way of saying arrest. Whatever I can do with an arrest, I can do with probable cause, because probable cause equals arrest, right? So even though you haven't actually spun the guy around and put the cuffs on him, you can go ahead and search him as long as you've got that PC, right? In fact, famous case about highly evanescent evidence, Cupp versus Murphy, about one of my favorite crim law cases about a guy who had just strangled his wife and still has tissue from her neck under his fingernails, and goes into a police station to talk voluntarily. And as he's talking to the police, he's got his hands in his pockets and he's rubbing his hands against the coins and keys in his pocket to try to get the blood and the tissue out of his fingernails. And the cops at that point have probable cause, but they haven't arrested him. So what do? They grab his hands, they bag him, and they essentially search him by taking whatever's left under his fingernails, they subject it to some kind of analysis. Turns out it's his wife's tissue. And that was a classic case of, hey, they had PC, but they didn't place him under arrest. But still, they were allowed to search him because they had that PC. They had that probable cause, right? Okay. It has to be, generally speaking, contemporaneous with the arrest. It doesn't have to be, it has to be about the time that you place him under arrest. But it can't be, for example, you can't arrest the guy and then, let him, then 3 hours later search him incident to arrest. Nor can you arrest him and then, let him go home for a while and then search him after he's home. It has to be not remote in time and place from the arrest. So, word to the wise is, generally speaking, if you have the PC, whether you've arrested him or not, search him fairly quickly. And will be referred to as contemporaneously with the arrest, at about the same time as the arrest. Don't let too much time go by. It has to be fairly soon after the arrest, right? Okay. And obviously, why? You should know, now that we just talked about it, why am I allowed to search you incident to arrest? Why? I think was it on your last quiz, or maybe it was 101? I get so mixed up. Anyway, the reason why I'm allowed to search you incident to arrest is public safety, right? Public safety, destruction of evidence. So when is my greatest justification to search you after the arrest? When are you most likely to hurt me or destroy evidence? Right now, after I've arrested you. So generally speaking, you want that search incident to arrest to be as contemporaneous as possible. Now, let's talk a little bit about the history of search incident to arrest and where this whole idea of scope came from. Because you might know, where can I search? Where can I search? Scope. Where can I search in a search incident to arrest? And you should know that the answer now, this is, spoiler alert, is that I can search in what's referred to as the wingspan, right? And the wingspan is any place into which I might reasonably reach to grab a weapon, destroy evidence. But the first case that started this off was a case named Rabinowitz. And that is the password for today. Yes, that's right. When you hear that, write it down. I'm writing it down, so you should too. Rabinowitz, U.S. versus Rabinowitz, a 1950 case that was kind of the precursor to the search incident to arrest. Send that word to me in an email. All you got to do is, you don't have to say, hi, Professor Kramer. All you got to do is send me an email saying, Rabinowitz. Rabinowitz, I'll give you 100% for your video, for having watched the video. Please don't spread it around to people who haven't watched it. Be honest. But that's the password for this week. Okay, now what Rabinowitz said, there wasn't any wingspan here. Rabinowitz, this is pre-wingspan. Rabinowitz said that if I arrest somebody in their house, or anywhere really for that matter, I can search, this was the language of the court, I can search the area in the possession of and under the complete control of the arrestee. Think about that. Under the complete control of the arrestee, in the possession of and under the complete control of the arrestee. Interestingly, what was Rabinowitz arrested for? Again, these old cases are just a hoot. He was arrested for forging postage stamps. You ever heard of that? I have never heard of a prosecution of a man who forged postage stamps, but Mr. Rabinowitz did. Anyway, I found this, which is the forged. One of these is forged. I'm not sure which one is the forged one. I think it's this one. I'm not sure. Anyway, so that was the rule until Chamel came along. Now, what was the problem with the Rabinowitz rule? The Rabinowitz rule is what? Give it some thought. Let's say I arrest you in your house. Under the Rabinowitz rule, where can I search? I can search in that area of your house that is in your possession and under the complete control of you. Which means that if I arrest you in the basement, where can I search? Under the Rabinowitz rule, I can search the whole damn house. Can you imagine that? That I can arrest you in the basement or in the driveway, and then I can just go in and search the whole house. Why? Because the house is under your control. Well, that didn't last that long, right? And then along comes Chamel. And Chamel changes things. And what does Chamel say? Chamel says it gives it the so-called wingspan or arm span rule, right? Now, under Chamel, this is basically the wingspan. And please don't take out a yardstick and put your arms out and say, okay, Mom, measure me. So my wingspan is 72 inches, whatever. It doesn't work like that. It has to be applied reasonably. Again, it's any area into which a person might reach to grab a weapon or destroy evidence, right? It could be, as we know in a car, for example, under Belton versus New York, it was the entire passenger compartment was considered the wingspan, even though technically you might not be able to reach back. So don't look at it as a fixed measurement of your arms. It's not. It's a legal term. It's a figurative term, right? I put this picture up here. Under Rabinowitz, I was really glad I found this picture. I'm not sure what that is, but I think maybe it's a monkey with boxing gloves on, but I'm not sure. Anyway, under the Rabinowitz rule, if this is the arrestee, I've arrested this guy. Where would I be able to search? Under the Rabinowitz rule. Under the Rabinowitz rule, I'd be able to search everywhere that is under his complete control and possession, right? That's in his possession and under his complete control. It could be the whole house, the attic, the basement, the garage, the doghouse. Under Chamel, it's only that sort of where I can reach routine, right? By the way, if you see me looking up, I'm looking out the window, see if anybody's driving up my driveway. This guy in an orange pickup drove up my driveway a couple times the other night, pulled out, drove up, pulled out, drove up, pulled out. I was getting nervous. Anyway, it has to be that area that's in your immediate control and that area into which you could reach to grab a weapon or to destroy evidence, right? I mean, that's basically the definition, right? His immediate grabbing area. But don't take out a tape measure because it's not going to be that fixed an area, right? Now, does this help or hinder police in a search incident to arrest? I mean, let's face it, which was better for police, Rabinowitz or Chamel? In Chamel, I mean, under Chamel, if this is the arrestee, where can I search? I can probably search there and on the stove, and maybe up there, whatever that is up there, right? That's under Chamel. Under Rabinowitz, heck, man, I could search the whole house. So clearly, Rabinowitz was better for law enforcement than Chamel. But look, it's the law of the land. It is what it is, and we got to live with it, right? Okay. Now, something that we didn't talk about in ADJ 101, and that is there anyone else that I can search in a search incident to your arrest? If I arrest you, is there anyone else I can search incident to your arrest? Well, turns out there was a Supreme Court case that covered that, of all things. It was a Bowie. It was a Maryland case named Maryland versus Bowie. Not Bowie as in the city in Maryland, but B-U-Y-E was the guy's last name. This was the question that was generated in the Bowie case. And that is, I mean, you look at these guys, right? Can police look for, and this is the language that the court used, was a confederate, someone who was an accomplice. If you've taken me in criminal law, you know what that means. Can I look for someone in a search, if I've arrested you, can I possibly find other people that you've worked with in the commission of the crime for which I'm arresting you and search them too? If they're nearby. I mean, I can't travel, to Chambersburg to find them, but if they're near the arrest and they're a confederate, can I search them too? And of course, you probably know the answer is yes. Why? Why under Bowie can I search them as well? Because those people that are confederates, meaning accomplices, people who work with, Confederate in the Civil War aspect means someone who was a member of the Confederate States of America or the Confederate Army, right? The Southern Army, the rebels, right? But in the legal sense, a Confederate is basically someone who works with me in committing a crime. Because the same reason that I have to search you after arresting you applies to the people who might be around you close by who helped you in the crime for which I'm arresting you. They might want to attack me and they might want to destroy evidence as well. So under the Bowie case, yes, I can search Confederates that are nearby at the time of the arrest as well, right? Why? Same justification. And here they are. All right. How about this, as I like to do? I want to serve an arrest warrant on someone inside a house. Okay? Fair enough. If I have reasonable articulable suspicion that there are others in the house as well, can I do a protective sweep of the house before the arrest? The answer is, and you should probably be able to figure this out by now, the answer is yes, right? I can do a protective sweep of the house anytime I'm in a house, whether it's for an arrest warrant of a named individual or whether it is for a search warrant inside a house. I can always do a protective sweep, right? Now, let's say in the protective sweep, I find somebody, right? What can I do with them? Well, I can do with them what I can do in any protective sweep, which is basically another name for Terry, right? A protective sweep of a house, and I find people. I'm looking for people and weapons. What can I do? Because the people are the ones that have the weapons. You know, the guns don't walk up by themselves and, you know, jump around, start shooting people by themselves. It usually has to be a human hand associated with it. I can look for people, and then I can frisk them because that's consistent with a protective sweep. Looking for people and weapons, people and weapons. Make sense? Okay. All right, now, this is what I would do. I'd probably give you credit for this in class, but look carefully. All right. This comes from the book, if I'm not mistaken, Combining Theories: The Protective Sweep and the Search Incident to Arrest. I'm going to read it to you. Two police officers arrive at Dave's house. Dave, defendant. I usually use names that begin with a D. With a valid warrant for his arrest. The officers were informed by a nosy neighbor that two of Dave's accomplices were in the house with him. The officers knocked, announced their presence, and entered the house. They found Dave walking down the stairs. He was placed under arrest. Fair enough. They had a warrant for him, right? Right after the arrest, one of the officers went upstairs and found drug paraphernalia on, not in, on a nightstand. Can this evidence be seized?
I want you to use all your skills and all your talents and all your knowledge to try to come up with an answer to this question.
Can that evidence be seized? So what you need to do is you need to go through the theories in your mind. Be mechanical, be methodical, be mathematical, right? Every theory is a separate sort of analysis. First of all, on a search incident to arrest, you know that I can, if it's a custodial arrest, any lawful custodial arrest, I can search into any area under Jamel into which a person might reasonably reach to grab a weapon or destroy evidence. Now, I arrest him under the stairs or as he's walking down the stairs. Do you think that searching the area that he just came from, right? He's walking down the stairs. Can I look in the room? Can I search that area incident to arrest? Well, there's an argument there that maybe I can, because that was an area that was at least recently, right, within his grasp and control, and an area in which he could have hid evidence or hid weapons. So on a search incident to arrest, what do you think? I don't know. I don't like it that much. I give it a 50-50 on a search incident to arrest, because once he's left the room, I'm not sure. But, you know, maybe, because it's still contemporaneous with the arrest, he just came from that area. He could have used that area to hide evidence or weapons. You know, maybe. Now, here's another question. What about as a protective sweep? Because remember, whether I'm in there on an arrest warrant or whether I'm in there on a search warrant, what can I do before I actually start arresting and searching? I can do a protective sweep. And what's a protective sweep? You go from room to room to room. Room 1, look for people, look for weapons. Clear! Room 2, look for people, look for weapons. Clear! And then once you've done all that and you make sure there's nobody hiding behind corners with a rifle, then you start your search. You look for your people, whatever. Is it possible that under a protective sweep, I could seize the stuff that is sitting on top of the nightstand? And I hope you're thinking about plain view from the old days when we talked about it. Because plain view, if I'm lawfully allowed to do a protective sweep and I see it in plain view, can I take it? If I reasonably believe it to be evidence, if it's readily apparent as evidence, if it's in plain view and I'm lawfully positioned, can't I take it? And the answer is yes, right? So all I want you to do is analyze these things. Come up with a conclusion one way or the other. As long as you're applying the right law to the facts, I don't care what your answer is, right? Now, just to make things more difficult, what if the officer found the paraphernalia inside a closed drawer of the nightstand? Well, it's an interesting question. What do you think? Under a search incident to arrest, can I search inside a closed drawer if I've arrested the guy on the stairway? Yeah, I'll be honest with you, it doesn't sound that great. It's not within his immediate reach and grasp and control anymore. There might be something in there, but I can seal the house and probably get a search warrant for that. right? What about on a protective sweep? Could I look inside a closed drawer of the nightstand? My feeling is it's a little more attenuated, right? Something inside a drawer is going to be, meaning it's a little bit further away in likelihood than I'm going to be able to search inside a drawer, because what I'm looking for are people and weapons. If I haven't found any people, the fact that there's a weapon inside a drawer or paraphernalia or evidence inside a drawer, it's going to be less likely for me to search that area. But I would say, as a protective sweep, easily the stuff that's on the top of the counter, on top of the night table, that's a slam dunk, man. So I hope you're going through these sorts of analyses, right, as we do this. I just got a couple more for you today, and then I'm going to end it. A little bit about search incident to arrest, and you and I have talked about this in other classes. It's near and dear to my heart. What happens if I've arrested the occupant of a car? What happens if the arrest is not somebody on the street, but it's somebody who was just arrested for driving while intoxicated, or driving while suspended, or possession of methamphetamine inside a car, or whatever else you might do in a car that generates an arrest, right? New York Belton was a great case. I loved it, argued it successfully many times until I came across one of the stupidest judges I ever, and I won't tell you his name. When we're in class again, I'll tell you. I loved Belton because Belton said that where the driver of a car is arrested, the police, the wingspan is interpreted to be the entire passenger compartment. I can place him under arrest, put him on the curb, then go back to the car, and I can search the entire passenger compartment under New York versus Belton. Dude, it was Supreme Court law. It was the law of the land, right? I didn't have to let you sit in the car while I searched the car. Well, as it turns out, rest in peace, New York versus Belton died. It died because it was killed off, also known as overruled, by another Supreme Court case called Arizona versus Gant, a 2009 case that says this, that police can only search the car of someone after arresting an occupant of that car if, number one, they have a reasonable belief that the arrestee, the guy you just arrested who was inside the car, might be able to get back to the car after the arrest to grab a weapon or destroy evidence. How likely is that if you've put him on the curb? Unlikely. And then the second possibility is, and this is more likely, is that if there's reasonable belief after you've arrested the guy, taken him out of the car, that the car contains the evidence of the offense for which he was placed under arrest. So, for example, if I've arrested him for let's say a little bit of a crack pipe, a crack cocaine pipe, which is paraphernalia, is an arrestable offense in the state of Maryland. I put him back on the curb. Might I have reasonable belief that back in the car, where's my fan? Pointing back there. That back in the car, everything's reversed. That back in the car, there's some cocaine sitting there. Then I can go back and search the car. But if it's just an arrest for, say, driving while suspended, and I've got him on the curb, under Gant, I can no longer go back and search the car. And this cartoon, I think, really sums it up. And that is, wait, don't cuff him and put him in the squad car until after we search his vehicle. In other words, let him sit in the car while we search the car. And he says, oh yeah, that's right, I forgot about Arizona versus Gant. Arizona versus Gant says once you take him out of the car, you can't search the car anymore as a search incident to arrest unless one of these two things is true, right? So generally speaking, Arizona, for me, that's the end of a beloved case, New York versus Belton. I just loved that case because I thought it was so useful. Great for prosecutors. Prosecutors loved it. Arizona versus Gant, it was really a dark day in the world of prosecution, because if I arrest a driver of a car and I take him out, put him on a curb, and put handcuffs on him, I can't get back and search the car as I could under New York versus Belton, unless I have reasonable belief that he's going to try to get back to the car, which he's not going to as long as I've arrested him properly, or possibly that there's, I have reasonable belief that there's something in the car that has to do with the reason I arrested him. Right? But besides that, New York versus Gant, man, and by the way, as this cartoon suggests, can you actually search the car while he's still in it? Can you? Can you have an orderly search of a motor vehicle while the occupant is still in the car? Of course not. I mean, what New York Gant is basically telling you is, hey, unless you got a really good reason, you arrest the occupant of a vehicle, you can't search the car incident to arrest unless one of these things is true. You got to get him out of the car. Once you've got him out of the car, no more New York versus Belton. Arizona versus Gant kicks in, and you are, as we like to say in Kansas City, hosed. So that's it for today. So you now have 2 videos for the week. Again, check your Moodle, check your emails. I've posted those videos for you guys on the poll, what they call a poll, which is the Dallas SWAT pulling fun off of a house, which I think shocks the conscience. Anyway, stay well, and I will catch up with you guys through video next week. And um, everything's closed down. Malls, parks, restaurants, bars, movie theaters. I don't know what you guys are